Hey everyone, and welcome to This Explainer. I am absolutely thrilled to be your guide today. If you've ever taken a look at the Philippine labor justice system and thought it looked like some kind of impossible bureaucratic maze, let me tell you, you are definitely not alone. Between the various commissions, the boards, and an absolute alphabet soup of government agencies, just figuring out where to go when a workplace dispute erupts can be completely overwhelming. But here's the good news. There's actually a distinct logic to the whole shebang. Today, we're going to decode that complex web of Philippine labor adjudication together. By the time we wrap up, you'll have a clear, practical survival guide to understanding exactly how labor justice is navigated, all the way from the very first complaint straight up to the Supreme Court. Let's get into it.
All right, here's our roadmap for today. First, mandatory peace, or SENA. Second, DOL versus the NLRC and the 5K rule. Third, the specialized referees. Fourth, rules of the game. And finally, number 5, the appeals ladder.
Starting right off with Section 1, Mandatory Peace, also known as SEA. Okay, let's dive into this very first, entirely unavoidable step in almost any Philippine labor dispute. Before the battle lines are even drawn and the lawyers start drafting heavy pleadings, the law actually forces everyone to just take a breath. This is called the Single Entry Approach, or SENA. What you really need to take away from this is that the system actively tries to avoid a full-blown legal war right out of the gate. Under Department Order No. 151, SENA imposes a strict 30-day mandatory conciliation and mediation period. So before you can formally commence an adjudicatory proceeding before a labor arbiter at the National Labor Relations Commission, the NLRC, or the Department of Labor and Employment, DOL, or even the Bureau of Labor Relations, both parties are required to sit down. You literally have to exhaust all possibilities of an amicable settlement first. It's essentially 30 days of mandatory peace just to see if you can talk it out.
Moving right along to Section 2, DOL versus NLRC and the 5K rule.
So what happens when mediation fails? That 30-day window closes, there's no handshake, and you have to file a formal case. Well, we hit our first major fork in the road. The absolutely crucial threshold here is exactly 5,000 pesos. Now, I know it might seem like a somewhat modest amount, but in Philippine labor law, this magic number literally dictates which government agency you'll be fighting your battle in. Let's compare the two paths, shall we? On one side, we have the DOL regional directors. They handle the recovery of wages and small money claims that do not exceed 5,000 pesos, but that's provided the employee is not asking to be reinstated to their job. They also handle occupational safety and health, or OSH, standards violations. But on the other side, we have the heavyweights, the NLRC labor arbiters. They possess original and exclusive jurisdiction over the major disputes, meaning if a claim exceeds 5,000 pesos or if it involves a claim for reinstatement, like in a big illegal dismissal case, boom, it goes straight to the NLRC. They're also the ones who handle claims for moral and exemplary damages and unfair labor practices. And this brings us to a really fascinating legal loophole. Actually, scratch that. It's more like a built-in safety valve. Let's say an employee files a small claim of 4,000 pesos with the DOLE regional director. Normally, as we just learned, that stays with DOL. But if the employer contests the findings and suddenly raises complex evidentiary issues, stuff that a DOL inspector just can't easily verify during a normal routine inspection, the regional director actually loses jurisdiction. The case must then be endorsed upward to the NLRC labor arbiter to be formally litigated. It's a pretty brilliant way to handle complex disputes that pop up in small packages. That brings us to Section 3, the specialized referees.
Not all disputes are just about simple monetary claims or someone getting illegally fired. The workplace is complicated, and some conflicts require highly specialized referees. If your dispute is about interpreting a collective bargaining agreement, a CBA, or enforcing company personnel policies, you don't actually go to a labor arbiter. Nope. You go to the National Conciliation and Mediation Board, the NCMB, and voluntary arbitrators. They're also the ones who handle seafarers' disability claims under their specific CBAs with seafarer unions. Now, what if two unions are fighting each other? That's an inter-union or intra-union dispute, and the Bureau of Labor Relations, or BLR, steps in to handle that. And then there's the big boss level, the DOL secretary. The secretary can actually assume jurisdiction over disputes that threaten industries indispensable to the national interest. Think about stopping a massive strike that could literally cripple the economy. They also have the incredible power to legally suspend the effects of a termination if it might trigger a serious labor dispute or a mass layoff.
We also absolutely have to call out the special protection for overseas Filipino workers, or OFWs, under Republic Act No. 8042. Money claims involving OFWs are handled directly by the NLRC labor arbiters. They have original and exclusive jurisdiction here, and what matters immensely for this is the concept of solidary liability. To put that in plain English, it means the local recruitment agency back in the Philippines and the foreign employer abroad are equally on the hook for any violations. This is a game changer because it ensures the OFW doesn't have to somehow chase a foreign company all the way across the globe just to get justice.
Moving on to Section 4, Rules of the Game. All right, so once you're finally in the room with the arbiter, we really need to understand how the game is played. Let's talk about the burden of proof, because the system intentionally tilts the scales depending on the severity of the claim. In illegal dismissal cases, the burden of proof heavily rests on the employer. The employer has to establish that the termination was for a valid cause and that strict procedural due process was followed. It is a serious uphill battle for the company. Conversely, in simple monetary claims, the burden is a bit more shared. The employee first has to prove they were actually employed and are entitled to the benefit, but then the burden shifts right back to the employer to prove that the payment was indeed made.
Now, this might literally be the most surprising fact for anyone who's used to watching courtroom dramas on TV. Labor tribunals operate quite differently. Under Article 227 of the Labor Code, they are mandated to use all reasonable means to ascertain facts speedily and objectively. They prioritize equity and the actual merits of the case over rigid legal technicalities. So, if you have a minor formatting error on a document, it's not necessarily going to get your entire case thrown out the window like it probably would in a regular regional trial court. And because they aren't tied down by those strict technical rules, the quantum of evidence required is also completely different. You don't need to prove your case beyond a reasonable doubt like you would in criminal law. You just need substantial evidence. What does that mean? It's simply the amount of relevant evidence which a reasonable mind might accept as adequate to justify a conclusion. It's really a common sense standard, designed specifically to make justice far more accessible to the everyday worker. And finally, we arrive at Section 5, the appeals ladder. So if the arbiter makes a decision and you end up losing, the stakes immediately shift into overdrive. Appealing a labor decision is honestly a lot like fighting through grueling boss levels in a video game. First, you appeal the labor arbiter's decision up to the NRC Commission proper. If you lose there, well, you can't just file an ordinary appeal. You have to elevate it to the Court of Appeals via a special civil action for certiorari under Rule 65. And if you still want to fight after that, your absolute final stop is the Supreme Court via a Rule 45 petition. It is a very steep climb.
Let's zoom in on that very first step for a second, appealing to the NLRC proper. The rules here are incredibly unforgiving. The aggrieved party has strictly 10 calendar days from receiving the arbiter's decision to file their appeal. And here is the absolute kicker for employers. If the decision includes a monetary award, the employer is strictly required to post a cash or surety bond that is entirely equivalent to the judgment award. If you don't post that exact bond within those 10 days, your appeal is instantly dead in the water. It's just not perfected. This rule exists specifically to stop employers from filing frivolous appeals just to delay paying the worker. Plus, think about this. What happens if the labor arbiter rules that an employee was illegally dismissed and orders them to be reinstated? Well, that reinstatement order is immediately executory, even while the employer is in the middle of appealing the case. The employer is essentially forced to make a choice right then and there. They can either opt for physical reinstatement, meaning they literally let the employee back into the workplace to do their job, or if the relationship is just totally broken, they can opt for payroll reinstatement. That's where the employee just sits at home but gets put right back on the company payroll during the entire appeal process. The timeline for climbing this entire ladder is tight, and it takes no prisoners. Like we said, you have just 10 days to go to the NLRC proper. If the NLRC proper rules against you, their decision is final and executory at their level. Your only real remedy left is to run to the Court of Appeals within 60 days. But keep this in mind. The Court of Appeals is only going to look at whether the NLRC committed grave abuse of discretion amounting to lack or excess of jurisdiction. They aren't there to reweigh the evidence all over again. Finally, if you manage to make it to the Supreme Court, they deal exclusively with pure questions of law. Well, we've definitely covered a lot of ground today. From the mandatory piece of SENA to the 5K rule, the highly specialized referees, the shifting burden of proof, and that unforgiving appeals ladder. The Philippine labor justice system is undeniably complex, but as we've seen, it's really a highly structured maze with specific pathways designed to balance the scales of justice. So I want to leave you with this provocative thought to reflect on. Now that you've seen the roadmap and understand how all these pieces fit together,
Do you know exactly who to call and what rules apply if your workplace rights are suddenly violated? Thank you so much for exploring this absolutely vital topic with me in today's Explainer. Keep learning, stay prepared, and I'll see you next time.